This is Bloomberg Law with June Grasso from Bloomberg Radio.
It's unprecedented. The Trump administration has sued all 15 federal district court judges in Maryland over a standing order that prevents the government from deporting a person for 2 business days after a habeas challenge is filed. It's the latest escalation in the Trump administration's battle with the federal judiciary. Joining me is immigration attorney Lina Baroudi. Lina, tell us why the Justice Department is suing every federal district court judge in Maryland.
Judge George L. Russell III issued a statewide standing order on May 21st that said any immigrant detainee who files a habeas corpus petition would receive a 48-hour automatic stay on the deportation. And the purpose of that was to ensure that detained individuals who filed for habeas were able to have a fair hearing and access to counsel, especially since there were so many habeas petitions being filed after hours or on weekends, creating an urgency where they were facing deportation without judicial review. The Department of Justice, under Attorney General Pam Bondi, labeled the order unlawful and undemocratic judicial overreach. And they basically filed a lawsuit arguing that the standing order violates the Supreme Court precedent requiring case-by-case injunctive authority, meaning that the chief judge of the district court could not just issue a blanket standing order for every case without considering it case-by-case. So the legal filing filed by the Department of Justice demands that the court and all 15 Maryland federal judges recuse themselves from the case and that an out-of-district judge oversee the litigation.
Have you ever heard of a suit against all the federal court judges on a bench?
No, it's unprecedented for the executive branch to sue an entire federal bench. Traditionally, the Department of Justice responds to unfavorable rulings through appeals, not lawsuits targeting individual judges or individual courts. This is really a direct assault on judicial independence and threatens the separation of powers.
But is the rule itself, the rule that the chief judge put in place, is that also unusual?
It's not very unusual for a court to have standing orders. In fact, many of the district courts and the Court of Appeals have standing orders for all types of various things, including stays in which an immigrant gets an automatic stay while the motion for a stay is played out. This often happens because in cases where deportation is imminent, when a case is filed in the evening or it's filed over the weekend, if ICE or DHS is allowed to remove a non-citizen without them having an opportunity to have a federal judge look at their motion for a stay or for a habeas, they're deprived of due process, and that ends up happening just because of the timing of their filing. So it's not unusual for judges to issue orders under the All Writs Act. So the All Writs Act basically says federal courts may issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usages and principles of law. And in fact, in this specific case, when the standing order was issued, the chief judge cited the All Writs Act and said this squarely applies to protect their ability to decide cases.
Is that argument stronger than what the Justice Department is arguing, which is that Supreme Court precedents mean that the judges have to rule on each case individually, not in a blanket fashion?
Well, I think the All Writs Act gives the courts wide latitude to run the courts how they see fit, and the court has inherent power to issue preemptive orders to prevent jurisdictional defeat. For example, they can issue standing orders to prevent a deportation before a judge can look at it. The Department of Justice's rebuttal is that the All Writs Act doesn't authorize blanket automatic injunctions, and federal judges can't preemptively enjoin executive action in every case. But this can happen in a very different way, which leads to the same result, which is a district judge can be on call 24 hours a day and issue the same exact standing order for any habeas. And so what the chief judge is doing as, for lack of a better term, a housekeeping matter, they're saying we're going to do this for every case anyway, so we're going to make it a standing order for this court.
And the Chief Judge explained in the order that there has been an increase in habeas petitions filed after court hours and on weekends. Is it pretty obvious why there has been this increase?
Yeah, there's a lot obviously going on in immigration right now. There's a lot of things that the administration is doing that are circumventing the legal process that has been set out for individuals to apply for relief from removal. As we've seen, they are kidnapping people in the street. They are dismissing cases of individuals who have sought relief in immigration court. And they are moving non-citizens around the U.S. in order to pick and choose which district courts we as counsel file habeas in. So there is absolutely an uptick in habeas petitions, and that's a direct response to what the administration has been unlawfully doing in the immigration system.
A lot of high-profile cases, immigration cases in particular, have been handled in this Maryland Federal District Court, including the case of Kilmar Garcia. And Maryland judges have put, some key Trump initiatives on hold in different areas. Maryland's Governor Wes Moore has called this a transparent effort to intimidate judges. Do you agree?
I do. I mean, the Kilmar Garcia case is such an alarming situation in immigration law. This is not a non-citizen who was just in the U.S. without status. This is someone who had had a hearing before an immigration judge. He had been granted protection from removal, and supposedly, due to administrative error, he was deported back to the very same country that an immigration judge found that he'd be persecuted and tortured. I don't believe it was an administrative error, and the fact that the Trump administration was so hesitant to bring him back tells us a lot. It was a test to see how far they could push to remove non-citizens.
So, as you mentioned, there's a question of who's going to hear this lawsuit, and the Justice Department is asking that the Fourth Circuit Court of Appeals randomly select a judge from another district.
Well, the Inter-Circuit Assignment Statute empowers the chief judge of the circuit, here the Fourth Circuit, to request a judge from another district within the same circuit by designation. So if there's no suitable in-circuit judge available, because all 15 are recused, the matter goes higher up. So here, it looks like what's going to happen is that the entire district, or even the circuit, is going to be conflicted out. So what will happen is the Chief Justice of the United States, John Roberts, will designate and assign a judge from another federal district to preside over the case. And this is going to be done in coordination with the Administrative Office of the U.S. Courts and the Judicial Conference. And when they select a judge, Justice Roberts will be looking for someone who doesn't have a conflict of interest, who has judicial experience, especially with constitutional, administrative, or immigration law, someone who's able to handle public scrutiny or politically sensitive issues, and someone who's obviously logistically available. And that's often going to be a senior judge or a retired Article III judge or a sitting judge from a district who has no involvement with similar issues. So
it sounds like this is sort of getting a little complicated then. Do you think that this case will take a long time to play out?
The complaint was just filed yesterday, and normally in these types of cases, they will file a motion for preliminary injunction. They haven't done so as of this morning, so that is what I expect will be next. And what's happening with all these cases with the administration and the federal courts is that it's almost like a game of ping pong. We are not seeing a lot of the litigation go to actual merits of the case because a lot of these cases are being decided in the form of motions for preliminary injunctions and injunctive relief. So if this were to play out, what will probably happen is a motion for preliminary injunction will be filed, and then the actual merits of the case will be ongoing for years. I expect this is going to be a long lawsuit because this is really a pivotal case in the tension between the judicial and the executive branch.
The Trump administration has brought so many immigration cases on an emergency basis to the Supreme Court. And the court often, as it did on Monday, issues orders without explanation. Is it confusing to litigants and perhaps even to judges?
It's confusing to everyone. It's confusing to lawyers. I mean, we are constantly back and forth and asking each other, what happened with this case? And what about this? And it's impossible to keep track of this. And imagine people who are being held in custody. One day they're going to get a credible fear interview. The next day they're being deported to South Sudan. The third day they're being removed somewhere else. The fourth day they might have a credible fear interview. It's ridiculous. I mean, not only is it a violation of due process and a violation of the United States obligation under international law, but it also makes it impossible for them to be represented by counsel, which is not a coincidence. So it makes it very, very impossible, one, for us to communicate with our clients, and two, for us to properly advise them because so much is happening all the time.
Well, it doesn't look like any confusion is going to be cleared up anytime soon, unfortunately. Thanks so much, Lina. That's immigration attorney Lina Baroudi. I'm June Grasso, and you're listening to Bloomberg. As court orders hem in the Trump agenda, there's been a steady drumbeat of rhetoric by the president challenging the authority and independence of federal judges.
You can't stop that with a judge sitting behind a bench that has no idea what goes on, who happens to be a radical left lunatic. These are judges that just want to, show how big and important they are. They're local federal judges, and they shouldn't be allowed to do it. Judges are trying to take away the power given to the president to keep our country safe, and it's not a good thing.
And Trump administration officials have followed suit, from border czar Tom Homan challenging a judge's authority.
I don't care what that judges think as far as this case. We're going to continue to arrest public safety threats and national security threats. We're going to continue to deport them from the United States.
To the Attorney General of the United States, Pam Bondi, not only criticizing a judge, but name-calling.
They're deranged is all I can think of. I cannot believe. I think some of these judges think they are beyond and above the law, and they are not. And we're sending a very strong message today.
This rhetoric hasn't gone unnoticed by judges, and their reaction has been to stay on the bench, refusing to retire. And this is true of judges appointed by both Democratic and Republican presidents. Joining me is Bloomberg law reporter Tiana Headley. Tiana, how many judges appointed by Republicans are eligible for retirement now?
So there's roughly 70 Republican-appointed judges who are eligible to take a form of partial retirement called senior status, or to just completely step down from the bench, and that was as of June 1st of this year.
And how many are taking retirement?
Very few, as the numbers tell us. There's been 16 new opportunities that have opened up for President Trump to fill judgeships. Those include folks who have announced their intent to retire, who've already taken retirement or senior status, or some unfortunate deaths this year. But comparatively to the first couple of months of other presidencies, this is not a big group.
No, it's not. 9 Republican-appointed judges assume partial or full retirement since January 1, and only 1 Democratic-appointed judge. And usually you'll see judges holding out and then retiring when there's a president of the same party that appointed them. So why are Republican-appointed judges holding back from retirement?
There's so many reasons why judges decide, even though I am eligible to, take this privilege of taking senior status or just retiring and enjoying that. Judges love doing their jobs. Judges find the work invigorating and intellectually. But, what we've seen under this administration, as former judges and even present judges would say, is this sort of unprecedented attack, open hostility towards the federal judiciary, even specifically from this administration, the Trump administration. And I would say this has been sort of a concern on both sides of the aisle, if you will, from judges appointed by Republicans, presidents and Democratic presidents.
Is there a difference in the people that the Trump administration is appointing the second term as opposed to the people, he was appointing the first term?
There is a difference in how this administration is thinking about the kind of judge they want to appoint to the courts. The president on several occasions and even just very recently has expressed his disappointment in his past appointees, that they are not ruling in the ways in which he felt that they would be ruling, particularly in cases related to himself and his administration's agenda. And so this time around, he has been looking to appoint more conservative jurists, lawyers who have a track record of sort of advancing these conservative legal movement issues, but in some respects, lawyers who have shown even a personal loyalty and commitment to the president. And that's what we have seen in recent nominee Emil Bovey for the Third Circuit.
That appointment has been very controversial for a lot of different reasons, including ethical concerns. He was Trump's criminal defense attorney, and at his hearings, he even denied that he was Trump's henchman, saying, "I'm not an enforcer." But he's seen as a loyalist to the president who's been rewarded with this lifetime nomination on the Third Circuit. Explain why that concerns some sitting judges.
So many of the judges, the Republican-appointed judges who are on the bench right now and are eligible, were appointed by more traditional conservative presidents. We're talking about Ronald Reagan, George W. Bush, George H.W. Bush. And so as I spoke with more traditional conservative lawyers for the story, for example, Greg Nunziata at the Society for the Rule of Law, these are institutionalists as far as the judges go. They want to preserve institutions and preserve precedent and preserve the ways in which our system currently functions. And, in the sort of allegations that Trump is trying to seek out loyalists who will sort of do his bidding, again, those are allegations. The idea that an institutionalist conservative judge can reflect on his ability to take senior status and create a vacancy and potentially be replaced by a judge who has sort of expressed more of a loyalty to the president than to the rule of law or maintaining and conserving our institutions. There is a tension there, and that is what Mr. Nunziata was speaking to in my conversations with him.
How have people reacted to the Bovey hearings? Because despite the fact that there is a lot to question him on, it didn't seem like the Republican senators were fazed by that.
That's a bigger question as to how the Republican Senate caucus sort of follows and answers to the president's agenda and what he wants. So that's its own conversation. But what I will say about how even the conservatives that we're speaking about have responded and reacted to the Bovey nomination, it's been extremely mixed. I would say that in speaking to conservative lawyers, what they felt was what was a unifying force during the first Trump term is his track record appointing traditional conservative judges with traditional bona fides. And now they're seeing, in their words, straying away from, just picking textualist judges, originalist judges, conservative judges from the bench, where it seems in their eyes that the highest credential is, do you swear your loyalty to this president?
The Federalist Society was particularly active, to put it mildly, in the selection of nominees for the first Trump term. Is the Federalist Society involved anymore?
As far as, the Federalist Society is a network of right-leaning lawyers, right? And between that network and the organization's former chairman, Leonard Leo, they had a pretty influential mark on who the president previously considered under his previous administration. This time around, for the reasons I mentioned, this president has found those appointees that he picked through that process as a disappointment. And so the sort of short answer for you is no, their membership in the society, in the Federalist Society, will not have as big of an impact on how the president vets nominees or potential nominees. What he seems to be looking for is this deep commitment to having litigated issues important to Trump and the Trump administration, as well as aligning with Trump's goals and agenda for his presidency.
And tell us about this group of former federal judges appointed by both Democratic and Republican presidents who've formed this coalition.
Yes, so they are the Article 3 coalition. They're a group, I would say a growing group of retired judges that were appointed by pretty much every single president going back to Jimmy Carter, I believe. And they have come out in recent weeks to say, you know what, in the face of the attacks and threats that we have seen against the independence of the judiciary, against judges themselves, and really what they're seeing as a huge misunderstanding about our system of checks and balances and what the courts really do and what their role is in our society, they've decided, you know what, we're going to band together and publicly speak out in support of judicial independence and to inform the public about what the role of the judiciary actually is in our democracy.
It really has been an unprecedented attack on the federal judiciary. Thanks so much, Tiana. That's Bloomberg Law reporter Tiana Headley. The SEC's Consolidated Audit Trail System, which requires broker-dealers and others to report trade data in real time, is at a critical juncture. The Commission is reviewing the market surveillance tool as some lawsuits push to abolish it entirely. SEC Chairman Paul Atkins said last month that the financial services industry and Congress have rightly pushed back on the seemingly endless cost increases and the risks of storing so much sensitive data together. Joining me is securities law expert James Park, a professor at UCLA Law School. Jim, tell us about this Consolidated Audit Trail System, what it is and what it does.
It's basically a record of trading in stocks on national markets, and it basically allows the SEC to track pretty much every trade that's happening. And this is a capability that the SEC did not have until relatively recently. After the flash crash of 2010, there was a concern that the SEC just didn't have enough information about increasingly complex securities markets, and so they passed this rule which requires various self-regulatory organizations to report this information basically the next day to the SEC.
I take it that traders don't like this. Does it cost them a lot to do this?
You know, it does cost them something. I mean, certainly record keeping is not free. And, you know, I think, you know, we're in a time of deregulation. And so to the extent that various broker-dealers and other parties responsible for providing this information, to the extent that they can, you know, argue to the SEC that this is costly, we don't want to pay these costs, this is the time to make that argument. On the other hand, you could say, well, you know, the $250 million you're spending on this is a nice investment in the integrity of markets, and that you actually benefit when the SEC knows what's going on, because investors will be more confident in the stock markets and more likely to invest. And so there's an argument there about cost that is going on, whether it's in the benefit of the various self-regulatory organizations to report this information. Another concern may be that they may be worried about, you know, this data being stolen. And and they may not want there to be a risk that somebody will be able to look at this data and somehow profit in trading against various firms. And that's not a far-fetched possibility. As we all know, cyber attacks are pretty constant and a threat. I think there are a couple of reasons why the industry would like to see the consolidated audit trail reduced or even repealed.
A conservative think tank and investor plaintiffs are suing in Texas federal court, arguing that, quote, the dystopian surveillance scheme was never endorsed by Congress and that it amounts to spying on U.S. traders. Do they have a strong case, you think?
They're raising privacy concerns, and I think, it's a similar argument that we're seeing in a lot of different contexts. We are being tracked and our data is being collected, something that some of us may be uncomfortable with. And, there was, until recently, personal identification for a lot of the investors was included in this information, and that could potentially be sensitive if it's stolen, knowing what every individual investor is doing. Is there some privacy concerns there? Possibly. And this is sort of the question of, do we want, cameras recording things that are happening on the street, traffic, because they're more likely to catch people who violate the law, right? And there may be an argument that I should have the privacy to trade in the way that I want to without being investigated for insider trading. And that is, I think, one of the uses the FCC has made of the consolidated audit trail is tracking unusual trading. And so there may be a privacy interest there. Whether the rule is authorized, Congress did pass a statute about the FCC regulating national markets generally, and I think there's a complex legal issue there as to whether that rule is within that authority.
So, Jim, the SEC chairman, Paul Atkins, what's his take so far on this? And as you mentioned, they're all into, deregulation now.
I imagine this is one of many issues on his plate, and I think that, certainly to the extent that he could find a way to reduce the costs, I think that is something that he might be sympathetic to. On the other hand, it's a pretty powerful tool that can be used to diagnose what are increasingly complex markets. We have high-frequency trading, algorithmic trading. And AI, I'm sure, is going to get involved as well. And stock markets are not always as robust and stable as we'd like to think they are. And markets can break down and, fall for various reasons and be manipulated. And this allows the SEC the tools to diagnose exactly what happened. And so I think it would be something that the SEC would be reluctant to totally do away with. We used to live in a much simpler world where the New York Stock Exchange is a physical person taking the orders, and it's just more centralized. But now we just have all sorts of different factors and considerations that people are using to game the market and manipulate it in various ways. So if you think of a cost-benefit analysis, which I imagine that would be an approach that would be used by the SEC, I would hope that, it would survive in some form. Are there ways we can reduce some of the burdens? I'm sure that's something they will take a very close look at.
Yeah, and because the SEC is generally understaffed, isn't it? So if it doesn't have tools like this,
it's very understaffed, and everyone's using technology. Why shouldn't the government also utilize technology in certain ways in order to perform its basic regulatory function? I think that's the argument. Now, on the other hand, you could say, well, it's the government. We are maybe more concerned because of the power of the government as opposed to private parties. But, I think, some would say that, well, I'm just as concerned of big tech companies having all this data about me as well. And maybe in order to regulate significant corporate interests on Wall Street, we do have to give the government the tools so that they can keep up.
This month, the SEC withdrew a proposal from Trump's first term that would have boosted the security of this. What does that tell you?
It probably means that they want to take another look at what they want to do. They want to start kind of fresh. Maybe it means that they'll go further. It doesn't necessarily mean, though, that they will go further, but I think they want to at least leave open the possibility that they do more than increase the security of the trail and implement other reforms. And, they've already done some things with, creating an exemption for personally identifiable information with an order. Maybe that would be put into a rule. Maybe there's some other things that they're working on as well. It's hard to tell, though, what that means. It may not necessarily be a sign that there's something drastically different about what they'll do.
There's been a lot of news about different departments and agencies, not so much about the SEC. So have there been any major changes since Trump took office?
It's a very good question. I think they've moved slowly, from what I understand. One of the things, I'm always interested in is enforcement. My understanding, they have not yet appointed a director of the enforcement division, although I think they have done a bit of reorganization of the various regions. And, I don't think it's necessarily a major set of reorganization. On the enforcement front, they've also basically made it a little bit more difficult to open investigations of corporations. They passed a rule basically saying that if the enforcement staff wants to open an investigation, they have to get a majority vote of the commission, the 5 commissioners who sit in Washington. They have to review the request, and that would allow them to open an investigation. That's a change back, starting in 2009, after the Madoff scandal. Enforcement was streamlined a bit so that you could open investigations without going to this 5-person commission. So that is, a significant change. What it signals on enforcement is that the FCC wants to centralize enforcement decision making to a greater degree than the prior administration. The risk of that, though, is that the investigations will be slow. So those are the things that I've noticed.
It's great to have you on, Jim, as always. That's Professor James Park of UCLA Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.